All right, we're ready to go. We're good to go. We're calling to order public meeting number 236 of the Massachusetts Gaming Commission on February 22nd at our offices in Boston. First item on the agenda, as usual, is the minutes. Commissioner McDonald.
Thank you, Mr. Chairman. I move that we approve the minutes of our meeting on January 31st, 2018, as they appear in the packet, subject to correction for typographical errors and other non-material matters.
Do I have a second?
Second.
Any discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
And I further move that we approve the minutes of the meeting of February 7th of 2018, also subject to correction for typographical errors and other non-material matters.
Second?
Second. Just a note on the top of page 2, where we reference our CFAO and Agnes. I know we've talked about this a couple of times, making sure that we try to be consistent and professional and keep a person's job title kind of in front of their name, as we consistently do in other pieces of in other parts of other meeting minutes.
So you would want that for
Derek.
both of those individuals?
Yeah.
Oh,
We'll make that correction.
anything else?
So amended.
That's as amended. All in favor?
Aye.
Opposed? The ayes have it unanimously. Next up is the Investigations and Enforcement Bureau, represented today by Loretta Lilios, the Deputy Director of the IEB and Enforcement Council, Chief Enforcement Counsel.
Good afternoon, Mr. Chair and Commissioners.
Good afternoon.
The first item we have is the suitability of an MGM qualifier for your consideration this afternoon, and that individual is Mr. Scott Howitt. He's the Senior Vice President and Security Information Officer for MGM Resorts International. You've already seen the investigative report, and I'll give a brief summary now. Mr. Howitt joined MGM in 2015. It's his first position in the gaming industry. The IEB designated him as a qualifier in May of 2017. In the period between him joining the company in 2015 and his designation as a qualifier in 2017, MGM was in the process of putting its shared services model into place. During this period, Mr. Saeed Esfahani, MGM's Chief Information Officer, who was qualified in June of 2014, oversaw the IT security function. Later, the positions were split, and Mr. Howitt now reports to the Chief Operating Officer, Corey Sanders, who is also a qualifier. Mr. Howitt submitted all of the required forms and requests for additional and updated information. He was interviewed by video conference by the investigators, Sergeant Michael Banks from the State Police and financial investigator Susan LaRosa. He cooperated and was forthcoming in all respects. As with the other suitability investigations the IEB conducts, we verified his identity, confirmed his financial stability and integrity, reviewed litigation history, and searched for criminal records. Mr. Howitt's responsible at the executive level for personnel and operations of the information services, the information security, security information, security policy, and awareness departments. He supervises teams that monitor security tools, conduct analysis of security information threats, and conduct cybersecurity investigations. He also supervises a team which oversees the architecture of new gaming and solutions to ensure that they are secure. He is a graduate from the University of Texas with a degree in physics. He worked for several small companies as a systems engineer and then as a chief information officer at Benefit Mall in Dallas, Texas, before joining MGM. In addition to Massachusetts, he submitted gaming applications in Maryland, New Jersey, and Nevada. The Nevada Gaming Control Board and the Maryland Lottery and Gaming Control Commission reported that his licenses are active and in good standing with no derogatory information. He is still pending by the New Jersey Casino Control Commission. Mr. Howitt's active in 2 professional associations. He's a member of the board of directors of the Retail Cyber Intelligence Sharing Center, a group for cybersecurity professionals to share knowledge in the cybersecurity field. He does not receive compensation for that role. He's also a commissioner on the Nevada Commission on Homeland Security Cybersecurity Committee, where he also serves as a volunteer. And this committee, which is made up of both public and private sector stakeholders, as well as the college and university community, makes recommendations to the Nevada Homeland Security Commission on cybersecurity issues. Mr. Howard has demonstrated to the IEB by clear and convincing evidence that he's suitable, and the IEB recommends that the commission vote to find him suitable as a qualifier for MGM Springfield.
Comments?
Well, I think first of all, it's a very clean report, and so I agree with the recommendation. But secondly, it's really an important position, and I found it interesting that they do a public-private partnership in Nevada, frankly, because that's not something that I'm well aware of. Those two groups sharing information to have the best possible outcome from the state. So that's just a aside when I read that.
Sure.
But I again, a very clean investigation, no issues whatsoever, and I would move that we approve Mr. Howard, the Senior Vice President of Security Information Officer for MGM.
Second?
Second.
Any other discussion? Any other comments? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you. So the next item on the agenda is listed as a WIN update, and I'd like to give an update on the status of the investigation into WIN's ongoing suitability, and that status is that the IEB's investigation is underway. It is an active investigation, and it is a priority. I can report that the IEB currently has adequate resources to conduct this investigation and also to meet its other responsibilities, in particular for the opening of MGM Springfield and the ongoing monitoring of Plainridge. We understand that there is the ability to access additional resources as necessary. We're actively evaluating future needs, but presently we are okay. I'm sure you understand that the IEB does not intend to provide the Commission or the public with the details of this investigation until it is completed. This sort of confidentiality in active investigations is, as you know, a common practice. It was the IEB's practice with the initial investigations into the suitability of applicants for gaming licenses, and it's important that the practice be maintained now. The Commission is the ultimate arbiter on matters affecting the gaming license. The 5 of you are the decision makers regarding the gaming license. When the IEB concludes the investigation, which I can assure you is a priority, you can expect that the IEB will present the evidence and any recommendations to you. To maintain the integrity of the investigation, it's crucial that the IEB conduct it independently. The Commission will need to wait until the investigation is completed and the evidence is presented so that all 5 of you are working from the same set of evidence. An independent investigation will ensure that the Commission can maintain its impartiality so that you can carry out your decision-making function at the appropriate time in a fair and unbiased manner. It's understandable that you may be interested in detailed updates of activity or progress, but we all need to keep our eye on the greatest interest here, which is the public interest in the integrity of the process. And I know that we're all committed to conducting the investigation in a way that ensures public confidence in the integrity of the process.
Any thoughts on that?
Yeah, well, I thought your first point was where you say it's best practice. It's really best practice not to update publicly because it really would affect the outcome of the investigation. If you reveal what your investigative strategies and methods are, frankly, they would be much less effective. So I just think that's important to note and certainly I understand and agree with that, with what you're doing. So we will we certainly trust the team and know that you'll present us with a final product when you're completed with the investigation. So I just wanted to make note that that's why it's the best practice. It's really a very important reason for that. So
And I would just to elaborate on that point, you made a point. Commissioner Cameron is a very experienced law enforcement official, a very experienced investigator. And when this began back, I think, at the end of last month, you made a point of talking about there needs to be the time to do this methodically and thoroughly. There is obviously tremendous interest. We have tremendous interest. The public has tremendous interest, and there is a legitimate purpose to do this as quickly as we can. But I think part of our job here is to give you the space and the time to do this right. The stakes are very big. The issues are very big. A lot of people are involved. And we need to make sure that when we finally come to a decision-making process or processes, that you have had the time and space to do this absolutely right. So we encourage you to do it as quickly as you can, and you will. But we will support you in your need to take the time to do it right. Anybody else?
Well, maybe they just agree, but also there's another side of this, which is as part of this process, the applicant, or in this case, the licensee, but we did it with applicants, will have the ability to respond or clarify or whatnot as part of the process, and that's also very important for us to remain in the position that we are. Let the investigative team continue with their process, because the licensee will be afforded the opportunity to respond however they see fit, if we ever get to an adjudicatory hearing or something similar. So I think it's also very important in terms of respecting the rights of the license holders as well.
Anything else? Okay.
Okay, so moving on, there is another matter involving a contribution in the amount of $2 million that was made to the Republican Governors Association in October of 2014 by Wynn Resorts Limited. Recently, this office received a letter from the 3 Democratic candidates for Massachusetts governor inquiring about Wynn's contribution to the RGA that was made back in 2014. That letter, which we received earlier this month, suggested that the Wynn donation may have improperly funneled campaign contributions to then gubernatorial candidate Baker and now Governor Baker in violation of Massachusetts law. In light of that letter that we received this month, Chairman Crosby and the executive director asked me to report on, was the IEB aware of the contribution to the to the RGA at the time in 2014, whether we reviewed it, and what were our conclusions? The short answer is yes, the IEB did look contemporaneously in 2014 at the $2 million contribution to the RGA. We did look at whether it was a prohibited political contribution. We worked in conjunction with our legal division, Catherine and Todd. We discussed this with our gaming consultants, Michael and Carol. We were in contact with the Massachusetts Office of Campaign and Political Finance, and we communicated with General Counsel for the Republican Governors Association. Ultimately, we concluded that based on the evidence that we reviewed, the contribution did not run afoul of Massachusetts law. I'd like to briefly set out a timeline for you to review what we looked at in 2014. On September 17th of 2014, the Commission made the determination to award the Region A gaming license to Wynn Mass LLC. 2 weeks later, on October 1st of 2014, Wynn made the $2 million contribution to the RGA. This contribution was a matter of public record, and I should be clear that on this matter, there were no efforts by Wynn to conceal the contribution. That same day, October 1st, 2014, the RGA made a $1.1 million contribution to the Commonwealth Future Independent Expenditure Political Action Committee. And on October 10th, 2014, the RGA made another $1.1 million contribution to the Commonwealth Future PAC. This PAC paid for ads supporting then Republican candidate Baker. The current concern in the letter is that, in essence, the Wynn donation to the RGA funded the Baker campaign. Our review did not find evidence to support this. There are 2 statutes at issue that we reviewed in our analysis, and there's a memo in your packet that follows these two provisions. The first is Chapter 23K, Section 46, which is part of the gaming law. That section prohibits applicants for gaming licenses from making certain political contributions. The rationale for that provision, I think, is pretty obvious. It's that no company or person, while the application process for a casino license is pending, should be permitted to influence or potentially influence the award of the license by making any political contribution. And the commission enforces that provision in the gaming law. As I stated earlier, the contribution to the RGA was not made until after the commission determined to award the license to Wynn. Thus, Wynn was no longer an applicant on October 1st, 2014. The determination had been made by the commission, and the commission had had its final vote. So this restriction on political contributions by gaming applicants was no longer in effect with respect to Wynn. The second provision of law that is applicable here is Chapter 55, Section 7AC. This provision is part of the Commonwealth's campaign finance law. It applies to gaming licensees, and it prohibits gaming licensees from making political contributions in an annual aggregate amount over $200 to any one candidate or a candidate's committee or any other political committee that is subject to Massachusetts law. And that provision in Chapter 55 is enforced by the Office of Campaign and Political Finance. Under this law, Wynn, as a gaming licensee, would have been prohibited from contributing to the Baker campaign or contributing to the Commonwealth Future PAC. The evidence that we reviewed did not show that Wynn's contribution to the RGA did either of these things. The RGA is clearly not a candidate or candidates committee under Section 7A, and also the RGA is not a political committee subject to Massachusetts law under this statutory scheme. We learned that the RGA is a nonprofit organization organized under Section 527 of the Internal Revenue Code, a federal code. 527s, as they are known as, generally work to actively influence elections and policy debates, but do not generally advocate directly for the election or defeat of specific candidates. We learned from our independent research and from our gaming consultants that it is not unusual for gaming companies to make contributions to national party committees, both the RGA and the DGA, for example, and that these organizations are sophisticated multi-state organizations. It is true that the RGA made $2.2 million in donations to the Commonwealth Future PAC within 10 days of the $2 million donation from Wynn to the RGA. So it is understandable that someone might speculate that the money was funneled from Wynn to the RGA to the Commonwealth Future PAC. And I put funneled in quotes. However, the public record of contributions shows that in the 6.5-month period between May 28th, 2014 and December 19th, 2014, the RGA made 11 separate contributions to the Commonwealth Future PAC, totaling over $10 million. 6 of them came before October 1, and 4 of them came after October 1. Also, General Counsel for the RGA informed us that the Wynn donation was placed in an account at the RGA used for general expenses, that the contribution was not used for political candidates, and that no funds from the Wynn contribution to the RGA were distributed to the Commonwealth Future PAC or to Governor Baker's campaign. We credited these statements. The information from the General Counsel of the RGA was consistent with our own research and with the information provided to us by our consultants. The evidence of the substantial sums that the RGA contributed to the Commonwealth Future PAC in this time frame, which were well in excess of Wynn's donation to the RGA, taken in conjunction with the common practices of the RGA with respect to gaming funds, and the representations of the General Counsel for the RGA, persuaded the IEB that the Wynn donation to the RGA did not amount to a prohibited contribution under Chapter 55. I also note, as I noted in the memo, that the IEB was in contact with the Office of Campaign and Political Finance back in 2014 about this matter, and that the OCPF, which enforces Chapter 55, has not initiated any adverse action against Wynn under Section 7A of its statute. So, to be clear, during the period when Wynn was an applicant, the IEB confirmed that it made no prohibited contributions under the gaming law. And so that goes back to the period when it was an applicant. We look during the application period at what, if any, contributions are made during the applicant period, and that information is part of the Wynn suitability report. So there were no prohibited contributions during the period when Wynn was an applicant. And based on the information that we reviewed back in 2014, I'm satisfied that there was no contravention of Massachusetts law and no lack of compliance based on the information that we reviewed at that time. Of course, I understand that monitoring political contributions by our licensees is important, and it's especially important as we enter a new election season. And with that said, as we have said many times before, suitability is ongoing, and if additional details, additional facts, additional evidence come to our attention, we will pursue them aggressively. But essentially, that is my report to complement the memo in your packet about what we did back in 2014.
So the work was done at the time that all of these contributions were made because you wanted to make sure, is that correct? You
That's
wanted to make
correct.
sure that everything was legal. And this new letter came to light, and what you did now was review the work that was done then, and in doing that review, conducting that review, nothing has changed, correct?
Based on the review of the evidence as it stood then, we continue to be satisfied with the conclusions that we made.
And you just said, which I think is important, if you received credible information that you did not have in the past about an allegation of distributed funds that may or may not have been illegal, you would take a second look.
Absolutely, of course.
Thank you.
Anybody else?
Well, just to follow up from what Commissioner Cameron said, perhaps stating it a slightly different way, has anything come to the IEB's attention since the initial investigation was done in 2014, which in any way affects the conclusions which the IEB came to in 2014 with regard to this?
Nothing, there has been no additional information that has come to our attention, but should any additional information come to our attention, we would pursue it.
And in the course of your investigation, did you determine whether the RGA has any particular policies with regard to earmarking of contributions from individuals or entities and subsequent contributions to political action committees?
It is our understanding, based on our research, that there is no earmarking to particular candidates.
Okay, when you say there is no earmarking, you understand that they have a policy that forbids that?
That's my understanding, correct.
Anybody else?
And one of the things that I just picked up, I guess, as part of this, is that the contribution came from Wynn Resorts, not from Mr. Wynn himself. Is that?
It came from Wynn Resorts, which is a qualifying entity for the
Right.
Wynn Mass license. And with that designation, Wynn Resorts would still be subject to the two statutes in
Right.
question.
am I remembering correctly that when you did the initial work, and I think part of your finding was over many, many years, they've made many contributions to both Republican and Democratic organizations?
That is my recollection as well.
This is sort of a technicality, but it's clear that that Wynn was not an applicant when the contribution was made. And for our purposes, that's by far the biggest issue. We were in that sort of funny period between the time we decided to make the award and the referendum. And maybe you could argue whether they were a licensee or not, even though they clearly were not an applicant. What's your thinking on that? How did you address that kind of
You're
conundrum?
correct in your,
Just for the record, if they weren't a licensee, they could do whatever they wanted. So this is not a potential negative, it's just a peculiarity in the fact.
right, and you're pointing to the award, the decision, the agreement to award the license, which was made in that time frame where there was a ballot question looming within, I think 60 to 90 days from the agreement to award the license. So your award was done in the form of an agreement to award, and as I recall, it was because otherwise Wynn would be required to submit a non-refundable $85 million fee, potentially 90 days later, to have gaming, not allowable in the Commonwealth. So for purposes of the analysis under Section 46 of the gaming law, I did look at it as a binary. Your Section 46 talks about being an applicant. It doesn't talk about being an applicant or a licensee. It talks about no applicant shall do this. So it was, under the analysis for 46, a binary concept. And when
Binary meaning applicant or not.
applicant or not. So given what the award of the license said, and given the final vote of the commission, it was viewed, we viewed it as Wynn was no longer an applicant, certainly for purposes of 46.
Yeah, my recollection is that they were licensees. They were just a conditional licensee on that fee, on the consideration of the fee, because that was.
Our regulations provide that your decision is made when the vote is taken. So once you voted to award them a license, they became a licensee.
Well, they were. So they
Yeah.
even by our own regs, they were a licensee.
Your decision is, it's when you take the vote, your decision becomes effective.
Well, that answers that question. Okay, good. Anybody else questions on this issue or anything else for Councilor Lilios?
No, thanks for your memo. It's really well articulated.
Yeah. Well, and it's always refreshing to have something come up and say, I wonder, let's look back, see how we handled that, and look back and see how that we handled it the way we would like to have handled it. So good job. Thank you.
I think it would also be helpful, obviously, there's an ongoing restriction on donations of employees of our licensees going forward. We don't track that as CPF does it, but it may make sense to, as we approach another election cycle, that, a reminder be sent to our licensees as to that piece of the statute, not the applicant piece, but now that they're a licensee piece.
That's correct, and we are implementing a protocol now to do those routine checks, even though it's a statute that we do not enforce, and there's communications with OCPF about this arrangement. But we, like we did in the first round for initial suitability, we made those inquiries of OCPF. It's pretty easy to do when it's public information, so we have incorporated that as part of our ongoing review of suitability.
Thank you.
Anything else?
Thank you.
All right, we are going to take a quick break before we get on with the rest of the meeting. We will reconvene in just a few minutes.
Thank you. Well done.
Thank you.
We are reconvening public meeting number 236 at about 1:35 or 40, and we are on to item number 4. Mr. Connolly, Director of our Licensing Bureau and Associates.
So yet again, I think I've cleared a room with my topic. Good afternoon, Mr.
Oh,
Chairman.
you've got others
Not
that
true.
clear them faster than you do.
Oh,
Not true.
We got a bunch of them.
This is exciting
Wait till we
stuff.
get to the regs.
exactly.
This is exciting stuff.
Uh, So I'm here today with Pat Mandamba and Mary Kate Martin from MGM to present on this topic because we wanted to reflect that this really was a collaborative effort between us and MGM to work through this exemption issue. And I wanted to upfront, thank them for all their help in this process. So we're here today to present recommendations to the Commission to exempt certain gaming service employee positions from the registration requirement. And I wanted to speak a little bit about the process as to how we got here. So at the outset, when the law was changed and passed to allow the Commission to exempt certain employees, we went through, frankly, all of the SER positions and went through them, internally and also with MGM to gain a deeper understanding as to the specific job functions of each of these positions, as well as where they sat in the hierarchy overall. So that we'd have a better understanding when we might eventually approach making those recommendations. At the January 18th meeting, Director Wells was here and spoke to you about the process in general, as well as putting forward some criteria for consideration. So criteria that we might use when we evaluate positions to make recommendations. At that time, the Commission provided feedback and further guidance on those conditions. And we use those to produce a form that we distributed to MGM to provide us additional information on each of these positions. It was actually called the Identification of Potential Positions for Exemption from the Registration Requirement by the MGC. We call it the PPE form. Yeah, I mean that's right out of federal bureaucracy there. That's why the room is cleared, exactly as Pat notes. So this form was important, though, because what it did was it provided us a consistent manner to gather information about each position that we might consider providing a recommendation on. It provides the Commission a consistent set of facts to when you are looking at and evaluating the recommendations from licensing and IEB. And finally, it will provide the record. So as we go forward, this is not obviously the last time I may or someone else may be in front of you with potential exemption recommendations, and it will give us a good record to look at, to see how we made evaluations in the past. And it contained, importantly, those 8 factors that were discussed at the January 18th meeting, which included whether or not a position involved work on the gaming floor, whether there were managerial responsibilities in any department, supervisory responsibilities in human resources, sales, or marketing, access to secure casino back-of-the-house areas, including executive offices without security escort, responsibilities for accounting or finance relating to the gaming establishment, right access, meaning the ability to change data in a gaming-related casino database, and finally, responsibilities that potentially impact the integrity of gaming operations, including access to confidential or sensitive information. So for each position, and it's all in the packet, MGM provided feedback on all those factors for each position under consideration. So once we received that set of PPE forms, we did a further analysis and again, worked very closely with MGM to make final recommendations, which encompass 127 jobs with an asterisk there, and we'll get to that in a second, encompassing 870 employees. And just to note, that is nearly 60%, there was my Boston accent, 60%, 60% of the eligible SER positions that could have been put forward for exemption. This is not, as I mentioned a moment ago, the end of the process. This is really the middle. I fully expect, again, to be in front of you with further recommendations to include some of the entertainment block employees, which I believe, and MGM can answer better than I, but I believe will largely be vendor employees. So some of the facilities that are part of the entertainment block be run by vendors. Those employees by our reg would be considered gaming service employees. We fully expect that we'll go through the analysis of potentially exempting them. And also, there may be additional positions, as you've done your analysis, that you ask us to consider that we haven't already considered. One position, actually two positions, but two different flavors that I want to point out is the position of porter. So utility and casino porters, essentially those folks that clean. The casino porters in particular are focused on cleaning the gaming area, so around machines, table games. And the utility porters do, my understanding, more general cleaning, but specifically if there's a bigger job, more complex job in the gaming area, would come in and do that.
Is there a separate a different category for people who clean elsewhere in the gaming establishment, but like at the movie theater or at the hotel or whatever?
There are several different categories of porters, but the one that I think that Paul is specifically referencing, the utility porter, which is 16472. It's on the last page of Paul's very handy dandy chart here.
Yeah.
We're going to withdraw the request for an exemption for that. There was an inadvertent mistake in the information that was given to the commission. We literally, within a few minutes before the meeting, we realized there was a mistake, and it's just going to be part of our continuing discussion. We want to pull 16472, which is utility porter.
Okay, so utility porters who are people that are called in apparently for big cleaning facility projects on
They
the
are
floor?
actually, since it was actually my first position in the casino industry in 1981 at Harris, Atlantic City. Yes.
Is that right?
I was a carpet cleaner at Harris.
Really?
Yeah. When I was my end of my freshman year of college.
I was a first-year trooper. I didn't run into you, though.
Yeah.
That was probably a
Well,
good
that's probably
sign.
probably a good thing, though, right?
That's why he is where he is today.
In any event, it's essentially the next step up from a porter, from an entry level porter that can clean a carpet and what have you. They used to be called heavy duty porters, now they're utility porters. But they do have entry into the casino floor, and we're continuing to have the discussion with staff about the porters in general. So that particular porter is, while it's not interchangeable with, it has some of the same duties as the casino porter position that's not on here. So that's about 46 positions. The other position that's not in here is about 100 or so.
Between the
about
two.
150 altogether that are up in the air. We want to continue that discussion.
Okay.
That was
But
an erroneous fact.
porters that function in the hotel, for example, they're on here already?
They are already on
Okay.
here, as
So-
well as the ones in the restaurants.
Right.
Okay, so the only porters, which we would think of as cleaning people, that have not yet been addressed are the utility porters and the regular porters who will be on the casino floor, maybe on the casino.
They may be on
Okay.
during the ordinary course of their duties.
And
they may
that's
be on
about
the casino
100
floor.
of the 625
Uh,
have
no,
not yet been exempt.
Oh, of the 625, yeah, it's a little over 100. It's 100 and change. Again, because
This
as
is a
Pat pointed
switch,
out,
yeah.
the utility porters are in there. MGM asked us to, remove the exemption. Licensing agrees. And what we're doing is we're in the process of getting additional information on both of those positions, and we may come back with a further recommendation in the future.
Okay.
But also of note, the compendium is really a living document. It's changes on the margins right now, but there may be new positions that are created, and we may bring those forward. But there's obviously some opportunity to revisit this list, including, and it's important to note that should you vote to exempt a position, anytime the job description changes for an exempted position, or any position for that matter, the licensee must notify us of that change. If it were a job change or change to a job description for an exempted employee, we would review that specifically to see whether the change has any impact on our recommendation to the commission for exemption, and if so, would bring it back perhaps for reconsideration to actually be classified again as a service employee registrant. So this is not, a terminal process in the sense that it can't be revisited. Any of these decisions obviously can be picked up and revisited at any time based on new circumstances.
Well, just listening, it sounds like it was a collaborative process. You worked well together to come up with this. And I think what's good about this, from my standpoint, is we have the comfort level, but we also have some things where we have we have some time to assess our risk. And I think that's really important to a brand new agency, just so we have that level of comfort. I know what happens in other jurisdictions, but I think it's really important that our team have that ability, and so that they, they can see firsthand where the risk is and where it is not. So I appreciate the collaborative effort.
I also appreciate the collaborative work. This seems to have been done in a very expedient amount of time, thinking of when the legislation passed, all this work to compile all the information and take a look in some serious level of detail at each position, how it met our guidelines or didn't meet our guidelines. So I think you, Paul, and your team, as well as the team from MGM. I do think, I'm encouraged by the numbers. I'm somewhat surprised and excited by the numbers of positions that are now going to be available for folks who, prior to the change, might have found themselves on the outside looking in at, a career-changing opportunity or life-changing opportunity. So I think that, the head count that you've come to agreement on is encouraging. It's certainly going to get a lot of folks out there, hopefully with action today, to start, going onto SkillSmart and putting their information in now, knowing that they're eligible. A couple of caveats to that is we obviously know that MGM, our licensee, also has your own background process that each employee is going to be required to go through for many of these positions. And I think as we think about a public education effort about what this change means and how it's going to impact people out there looking for a career at MGM, that we need to be mindful of the public education effort as to what the change means, but what it still entails. I had two quick questions to our licensees. Your workforce development plan was great at pulling out a couple of different positions that showed kind of a career pathway up the ladder. A lot of what's contained in here, you're a great example, was an entry-level position into the industry. Does MGM see career pathways associated with all of these jobs as people think about getting into a position, knowing that it has the opportunity to lead them somewhere?
For sure, and that has been the reason why we had this conversation to begin with staff, is that these are the positions that really are the gateway into the industry with us at MGM, Resorts International in general, but with Springfield specifically in mind, and they are the gateway. These are the positions that once you are part of that family, there is tuition reimbursement. We will help people get their high school diplomas. So that workforce, once you're part of that family, is critical, Commissioner, in these positions. And I think knowing now that Pat was in that entry level, he might be his picture, just like so many on Facebook and Twitter, to really show that progression, because that's what the company is about. We strive for that. There's people around this table that have started off in different industries, started at lower positions, have moved their way up, and we need to celebrate that success so people in Springfield can see that and see their lives are going to change in their family dynamics.
There were, as I read through all of these, and I saw Paul wince when I told him I did that. But there were two positions I'd like to ask you about. One is job position 16703, the assistant manager restaurant sommelier, if I got that correct.
Wine steward.
Sommelier,
The wine-
Sommelier.
Shows you how much I drink wine. In 10946, director of restaurants. These two positions look like they had responsibilities that tied into our guidelines. The assistant restaurant manager, how does that tie into the guideline around responsibility for alcohol sales, distribution, service, and storage? And the director of restaurants, look like it might bump up against our guideline around managerial responsibility. You have somebody who's hiring, training, overseeing operations, more of a senior level position than maybe I would have expected. But if
Right.
you can give me your thought process. On
Sure.
those two
So from
spots.
a director of restaurants perspective, that position does report up directly to Anthony Cardozola, who is our vice president of food and beverage. So we've got restaurant, food and beverage, food on one side, beverage on the other. So there will be a lead commissioner, and that is the director of restaurants. It's more of the implementation because that strategy does come from the vice president perspective. Though you are correct, there are reporting structures up into that director because they will come from the other outlets up into the director of restaurants. So that is more of the admin side. And then we've got leads within the outlets themselves. So if you can imagine, very similar to from a corporate perspective, you have the admin, the executives on one side, and then you have people running the facilities, specifically like a Meg Mathis, right? So there is managerial responsibilities there, but from a purchasing of alcohol perspective, that is driven by our director of beverage. And that position, I believe, is, yeah, is service, right.
And that was, Commissioner Stebbins, that was one of the perspectives we took when we looked at the positions as well, is even in potential areas where, you know, it may seem farther away from gaming, we still wanted to make sure at a managerial level we were capturing someone so that from a compliance perspective, we had someone who was responsible to the commission from a licensing or registration perspective for a particular unit.
Okay. Do you want to talk about the other spot, the assistant restaurant manager, the
Assistant
wine?
restaurant, what we captured,
Sure, yeah.
what we did capture was the person above.
Okay.
One above that person, so the.
You just
I'm
need to
sorry,
hit
so the person, the way that exemption worked was, in the outlets, the person that's the head of responsible for a particular outlet, there was no exemption for. And then at the assistant level, we requested the exemption for that person. But we still had someone that was responsible to the commission, looking up, responsible to the commission, and looking into the outlet, responsible for the overall activities of the outlet.
I actually wanted to also mention that I was very encouraged by the numbers and the process, as others have mentioned, but also in this particular instance, that there are some higher level positions exempted here, which I find very very encouraging. Not only for I initially had the impression that the majority, and they have been, would be exempted at the bottom of the pyramid, if you will. But there is at least a semblance of a career track or the beginning of one in these exemptions, which I think is very positive. A couple of the ones mentioned before, but you know, some executive positions because they happen to be in the food or the retail or the entertainment wing. So I think it's very positive.
Right, and so that was the whole analysis was done based on the qualities of the job as opposed to, you know, who we might envision would fill that position.
I just had a quick question about your internal background process. Do you outsource that, or is that something you handle internally?
We do outsource it. It is a third-party vendor called HireRight, and they do our drug and background screening after job offer.
National firm?
Yes,
Mhm. And you've had good success with them?
yes, we have.
Okay.
HireRight does the background checks for all of our properties.
Okay. Thank you.
Well, I just add my voice to the others. I was very, very impressed by the job that was done here, not only by you, Paul, and you do have a future in Washington waiting for you from the skill with which you designed these forms.
And the names.
But
And their names.
Yeah, Mary Kate and Pat as well. I really think this is an extraordinary job, and the thought that 870, service employees are now freed of that automatic exclusion on account of potentially minor conviction at an early part of their career is really very important for our larger workforce development goals. It's a great job.
Thank you.
And I just want to point out too, it wasn't at the commission level, it wasn't just me, but Director Wells and Attorney Lilios dove, as they often do, very deeply into the work here. There were a bunch of us on the team involved, so.
Yeah, my 2 cents worth, also, Paul, it's really, all of you, it's really impressive, and it did happen quickly, and it's great. And if you think about where we were, it's almost 1,000 jobs that are gonna be available to people who weren't, which is pretty good. Do I understand correctly, this will become a reg, right? That we will implement this as a reg, or how do we,
No, you can vote on this today,
Yeah.
as long as you're comfortable with it. It will not become a reg. The regs allow you to take this kind of activity.
okay. Have we got feedback from some of the constituent groups that worked on this with us? There were a lot of groups that were involved, community groups, who represented the folks who might have a chance to work in these jobs. Have we got feedback from those folks?
So I've
Sort of looking at
received
you.
feedback through Director Griffin.
Jill, do you want to come up?
No.
Jill,
You need a mic.
Thank you. The community groups that you're referring to have been following this very closely. I'd be very surprised if they weren't watching now, and I think they're very encouraged.
Okay, great, because they helped us get this law changed. Not sure we would have had they not pitched in, and it's important to get their feedback. And for the most part, it makes perfectly good sense to me. I think the standards that we came up with make good sense. This is a sensitive area. There's a learning curve, as Commissioner Cameron talked about. The only one that I have an issue with in my mind is the bartenders and wait staff who serve alcohol, either in general or particularly those who are not on the casino floor. I think if you're gonna do a registration of porters on the casino floor, you're clearly gonna do people who serve alcohol on the casino floor. I'm fine with that. But there'll be some number of jobs, I don't know, 10, 20, 30 probably, who will be off the casino floor, like in the entertainment block or in the armory when it gets done, who will be bartenders and wait staff that really are the kind of entry-level jobs that we've been talking about, this same category of people. And it personally, it doesn't feel to me inconsistent if we carve those folks out from our other criteria. In fact, it seems to me it's consistent with our criteria. But these are the criteria we came up with, and I'm just wondering what you all and anybody else for that matter think at this point. Would it be worth, I know you're going to be rethinking all this all the time. You've got other things you're considering. Would that be one to think about also?
For me, that this comes back to a risk. These are our licenses to issue. This is our first time issuing licenses. And just from my past experience with risk in casinos, that folks like the bartenders, they can present a risk in a number of areas. So
who don't have contact with the casino floors?
correct.
Okay.
Correct. So I just think it's important for us to start conservatively and issue these licenses with an understanding of the people that we're dealing with, and again continue to assess the risk. But yes, I'm familiar with just to set the tone that those folks we've taken a look, and then if we don't have a problem down the road, that would be something to consider. But right now, I'm comfortable with, because of our license and because of my knowledge of things that have happened in the past that may have implicated bartenders or wait staff, frankly. So
Do you
I'm
guys have
comfortable the way it is.
Do you have any thoughts about that from your experience and for anybody else?
Well, we worked with Paul and his staff, and we're very, very comfortable with the solution and what is put forth in front of you today. And as Paul said, we'll continue to have these conversations moving forward.
And we'll certainly have the continuing conversation as we fill out the entertainment block as well.
Right.
It might be appropriate there, but the process we've had with staff has just been an excellent process. So,
Because the entertainment block people, many of them will be third parties, right? And they're not included in these.
No, they would be.
Well, they will be, but they're not yet. right?
Not yet,
Yeah,
yeah.
not, their
Including the current
positions are not in the, in
Right,
the
so
current table.
if there were gonna be 100 employees at a movie theater, those numbers aren't in here, who will be exempt and who will
That's
not be.
Correct.
Which would be pretty much covered by the people I'm talking about, too.
Yeah,
It's a practical matter.
Essentially, what's left is some of the entertainment block, and there's still question as to whether they'll be, some or all of them will be operated by third parties. So you have that pool of employees, then you have the utility porter and the casino porter.
Right, okay.
They're the big chunks that are left. We've already addressed the utility porter, casino porter. We still need to
Okay,
have a
so we have
discussion about the
we have
entertainment
a,
block.
all of us have another bite at that apple. And I refer to the Armory, but at the moment, the Armory won't be programmed, right? So there won't be personnel assigned to the Armory, other than to hopefully lease it out to people to pay you tons of money.
Correct, but we do believe that in either March or April, we'll come back with some further suggestions when we fill out the programming of the facility.
Okay, all right, so we'll get to this. Go ahead.
Well, I just wanted to
Yeah.
answer your,
Just, could I make one
Yeah.
clarification that,
Seth Stratton.
yes, we'll be back here, on the 15th, but I just don't, the comment that the Armory won't be programmed, I think it will be programmed, and we look forward to presenting to you on the 15th how it will be, just not a traditional sense with staffing.
Okay.
Compendium of employees.
Yeah, that's what I meant.
Yes,
At the
I just
moment,
wanted-
there isn't a bunch of staff that we need to
Right.
deal with. Okay.
you know, I've been as liberal as you have been, Mr. Chairman, on this topic in terms of exempting from the get-go. But I think, as I mentioned before, this is a great result. The numbers are very encouraging. I would side with your comment, Commissioner Cameron, about starting now, wait and see. The best piece of this process that I didn't mention, that I think is very encouraging as well, is that we have the ability to come and redo. You can put in somebody else, another job description, you can take them out. And we could do this as a matter of course, as we get a lot more comfortable and of some of the details, some of the how especially how some of the duties overlap, because not any one person operates in a silo. So I think that as we continue, we may learn and get a lot more comfortable in certain sort of key areas. But for now, I think this is a fantastic result in terms of the numbers. 60% is a great result, and I think another big positive is that it will allow us, in terms of resources, to really focus on the thing that we really want to and need to on those other positions, which is to really to get those right, because we know we have, a job to do there.
I also am, once again, I'm impressed by the numbers. I think they exceeded what my expectations were going to be, which is great news. Again, for anybody who may have felt themselves on the outside looking in. And I would ask that, those positions I highlighted, we kind of flag those and kind of continue to monitor those. Again, we're being, unlike my liberal colleague, I'm trying to be a little more conservative, even though I sit to his left.
I thought you were the workforce development one.
Exactly. Well, I'm excited about this. I think this is actually, this is good news in terms of, because this is going to apply not only to MGM, but it is going to apply back to Plain Ridge Park. And right now it applies to, our Region A licensee as well.
Correct. Yeah, to 2 points. One, I think it's important, we will take a look at those positions you identified, because the most important thing through this process is that it's consistent and rational.
Right.
If it's not consistent, then it's not worth anything. And to that point, we still have to talk through internally what our recommendation, how to move this forward. But I think what makes the most sense, based on some concerns even regarding employment, is that this is now the model. And what we'll do is we'll take this model and we'll find the analogous positions at the other licensees and perform the same analysis. Frankly, without, fortunately for them, without that level of collaboration, they won't have to talk to me so much. We'll just tell them what the new schema looks like.
So we're through it now.
Yeah, they're through it now. Is that the heavy lift was once. So this is now, depending on the vote and everything and any further guidance or further decisions, we've built the model that will be extrapolated to the other facilities.
One thing that I want to raise, and we would look for MGM's help in trying to find a solution to this. When we did Plain Ridge, because everybody was licensed, everybody had to come in and be fingerprinted, everybody had to come in and be photographed. At that point, our research team was providing questionnaire tablets to employees, help us understand where people were coming from, what their previous employment status was. We're kind of losing that because now some of these people we won't see. So, I've had this conversation with Director Vanderlyn, and we need to think how we can do that in partnership with you to make sure that we're capturing all this good information, we're capturing all this good research, so that when we go back to stakeholders, we can show them that the expanded gaming statute kind of met the job hopefuls or the job prospects that the legislation intended. So we need to still kind of work on that piece and hopefully do that
And
with you.
just a little update, Commissioner, we do have Mark and the team coming in, I think, the second week of March. And Paul and I and team were on a call, I think 3 or 4 weeks ago, discussing this very thing, so that they won't have access to some people coming through. So we are going to come up with a plan to make sure we can get the survey results and working as a good partner with that side of the house also, sir.
That's great. Thank you.
Anybody else? Great. Thank you very much. Great job.
Well, I think I'll make
we-
a motion.
So, yeah, so I would say that the easiest way for you to make a motion is to move to accept what's in the packet minus position number 16472, because that's been withdrawn by MGM.
And just as a point too, it's being withdrawn by us because
Okay.
we're the commission is staff puts forward the recommendation. So just as to clarify, they're being nice enough to ask for it.
Mr. Chairman, I would move that the commission approve the gaming service employee exemptions as provided in the packet, with the exception of position 16472.
Second? Second. Any discussion further? All in favor?
Aye.
Opposed? The ayes have it unanimously. Thank you. Great job.
Thank you very
Thank
much.
you very much.
Thank you all.
All right, we are on to number 5, Legal Division, General Counsel Blue. Now you're gonna get an empty house.
Yeah, everybody goes home. So in your packet today, you have 6 regulations for your review and approval. The first one, the amendments to 205 CMR 13810, was actually the change that was mentioned in passing by Director Conley. This is the change that will require licensees to advise the IEB when they make changes in job descriptions and file them so that they can be reviewed. We're asking on this change for you to approve it on an emergency basis. You approved the prior change to allow for the change in the law on an emergency basis so we could implement it. We're asking for you to do the same here. We'll note that starting today, what we would like you to do is take each regulation in 2 motions, one to approve either the small business or amended small business impact statement first, and then to approve the actual regulation or amendments to the regulations. And I've drafted some suggested motions for you to try to make that simpler. So we're asking for your vote on the changes here to 13810, jobs compendium submission.
Motion?
I will move that the commission approve the small business impact statement for 205 CMR 138.10 jobs compendium submission as included in the packet.
Second.
Discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
And I further move that the commission approve the amendments to 205 CMR 138.10 as included in the packet and authorize the staff to file the regulations on an emergency basis pursuant to Chapter 22K, Section 5B, and further to take steps necessary to file the regulations with the Secretary of the Commonwealth and to proceed with the formal regulation promulgation process.
Second.
Discussion? All in favor?
Aye.
Aye. Opposed? The ayes have it unanimously.
The next set of amendments we'd like you to consider is on the agenda. It's listed as item C. It's 205 CMR 13304. This is where we took off the 6-month period on the voluntary self-exclusion list. We would ask you to approve the amended small business impact statement and that final regulation amendment for the final promulgation process.
I had a question or perhaps a potential edit. We did take out the 6 months exclusion list, which is great. And I think there's other reasons as well. 13304.
Yeah.
But under subsection E, the lifetime remains, and the language goes on to say that an individual may only select a lifetime duration after they have been on the self-exclusion list for at least 6 months. Should that read now at least 1 year? Because there's only been, my read of the prior regulation was that you had to have served at least
the
one,
short term first, right?
at least one of the terms. Without it now existing, I submit to you that it should be at least 1 year, meaning that it really is one of the prior options, one of the other options, not lifetime.
So we did not have that conversation with the responsible gaming folks. We can
Yeah.
certainly have that and come back to you with that change if that's what they were thinking. They did not advise us that they were thinking along those lines. So I would suggest we approve this change and then we'll go back and talk to our responsible gaming team and see what they think.
And I'm fine doing that. I just remember as being one of the commissioners involved in this, is that the notion was that somebody would go first through a self-exclusion. That would conclude, there would be an exit interview, which is important as part of the whole rehabilitation process, and then somebody might then decide to do a lifetime, which was, anyway, but if we could.
I agree. It's a very good point.
It
Because
is.
it either, it makes no sense to have it at 6 months. It either should not be there at all because now it's a full year, or it should say a full year because that's the only other option, but that's a very good catch.
Because there would be no exit interview at 6 months.
Right.
That would imply that somebody could get in the list eventually directly,
Mhm.
just by going through
Mhm. Mhm.
any one of them, and then after 6 months getting into the lifetime without that exit interview.
I was started to say, could we adopt this amendment subject to General Counsel Blue working out the wording? But there are some issues in that, actually, whether we were going to extend it to a year. That means a person comes in and says, I want to go on a lifetime. We say, sorry, you have to wait a year before you can go on a lifetime.
Mhm.
I'm not sure that's a good idea. I mean, I think that's something we need to think about. So
I think there's a number of ways, and that's why I would like to talk to the responsible gaming folks. There's a lot of ways that you could approach this. I mean, it wouldn't be necessary for someone to, if they picked a year, for example, on their first voluntary self-exclusion, if at the end of 6 months they wanted to extend it to a lifetime, I'm not sure that you necessarily need an exit interview. You could have a conversation with the GameSense people, the voluntary self-exclusion folks, and make that decision. So I think it is a little more complicated than just they were synced up to match. And I would like their input on that.
yeah, I think it'd be better that we don't vote on it. Let's
Okay.
just wait, and because it won't be this. It'll be something different, and it may be something we want to talk about.
Mhm.
So why don't we see if we can get on the agenda for the first?
So what we need to understand is we've taken this all the way through the hearing process. To make greater changes to this, we will start the process again. That will mean the 6 months is still available to people who want to select it. So just so we understand, it'll be the same reg in place for a little while longer without the changes we're suggesting.
We
I'm sorry I didn't notice that earlier, but it's a great clarification.
no, I'm with you. But the reason we're doing this is to adapt it to the regional, as you know, to
Yes.
the regional voluntary self-exclusion, which isn't in place yet. So I think extending it for another whatever is going to be a big problem. All right, so let's wait on this.
Okay, so we'll take that.
Good get, thank you.
The next regulation is 205 CMR, and it's a couple of regulations that have amendments to address floor plan issues. And I'm going to let Deputy General Counsel Grossman describe this to you.
Good afternoon.
Good
afternoon.
The regulation before you pertains to the to the floor plan that has to be submitted by gaming licensees to the commission. by way of background, you'll recall that at present there is a requirement that a floor plan be submitted to the commission. What this proposal does is divorces that requirement from the operation certificate and puts it under the internal controls. That would be done in an effort to streamline the process and give both the licensees and the IEB more flexibility to maneuver and to allow for amendments to floor plans and changes of that nature, as opposed to tying it to the operation certificate, which requires a full presentation to the commission and what have you. So that was the impetus for this change, and in the process of doing so, of course, we went through the existing floor plan requirements and streamlined some of those provisions and took out some things we didn't think we really needed in there, and that's how we landed where we landed with this. You'll see, of course, that we received some comments from Plain Ridge Park Casino on the proposal. Mr. Band and I have gone through all of the comments. We are content, as a general matter, that the proposal you have before you is still sound and that should generally remain as it is, in that it's in existence at the moment. We really haven't changed much of anything at all. We could certainly work with them to ensure that they understand the requirements. They have a floor plan at the moment that's been approved that meets these requirements. So with the exception of one area that I'll point out, we're not suggesting that any modifications be made to the existing draft. So if approved, essentially this would just become part of the internal control procedure. It would have to be submitted by both MGM and WIN in the future as part of the submission of their internal controls and could be amended in accordance with the terms here.
Todd, just getting clarification on the format here. That in green we've got the PPC comments.
Correct.
Was any of the language, is the language that's in red here, which is the proposed language, does that incorporate in any instance the comments that were made by PPC?
No, it doesn't. The red language is all the original language that was initially presented to the commission and brought through the promulgation process through the public hearing. PPC simply inserted their comments in green in the draft just to highlight what they were. But we haven't made any amendments.
And they're in red because, and you highlighted this, because we're essentially just taking them out of the operation certificate section and putting them in the internal controls. So there's been no change to the actual language that was there before. There has only been or has there been?
That's true as a general matter. We did certainly clarify some provisions. For example, when it comes to temporary amendments to the floor plan, that's on page 2 towards the bottom. We clarified that process as it was my understanding that there was some uncertainty as to exactly how that would work. Now we set out a very specific process for the temporary amendment of a floor plan. And we set out specific timeframes for the allowance of a temporary amendment, at which point you'd have to apply for a permanent amendment if you wanted to, and things of that nature. So I wouldn't represent to you that this is identical to the previous version, but certainly the essence of it is the same. It's the same content. And a lot of the items that have to be reflected in the floor plan itself are essentially identical.
But you've taken into account what PPC had asked you to think about, at least, and you're comfortable with the text that you're proposing here.
We are comfortable. There was one word that we would add in here to clarify one of the areas which we thought could use some further clarification on page 2 in provision K, which is up about a third of the way down. They asked whether essentially an automated coupon redemption machine is the same as M, which is a gaming voucher redemption machine. We will suggest that by adding the word kiosk into provision K, so it would read automatic coupon redemption machine or kiosk, that will help clarify that we are referring to something other than a gaming voucher that may be on the floor. But otherwise, we're of the opinion that everything really stands on its own. We could certainly, as with any regulation, spend pages and pages explaining exactly what we mean by everything. But we think, some things kind of stand on their own and we can work with.
We kind of like to have that authority ourselves anyway.
Exactly.
And most of their comments are asking for more detail, right? That's the majority of their comments. So you provided some of that, and other parts of this you feel like you can do with them independently of this document.
I think the IEB can work with PPC to ensure that their floor plan is adequate and meets the requirements of the regulation as it's written, without really any conflict or anything.
Is it a different person than the original?
Yes.
Okay, so you
The
worked with
different
one
person
person
do
to
it.
do the original?
Yes, and we'll work with this individual so
Okay.
they have a better understanding.
Okay.
Todd and I went over their floor plan today, and everything that we need is in theirs, and there wasn't any deficiency.
Right.
The language that kind of struck me that PPC had a question about is the kind of the opening section where it says gaming area depicted in the floor plan shall be arranged in such a manner as to provide optimum security for the gaming operations. And they're like, what's optimum security? It's kind of a subjective question, I would guess. What's the necessity or your experience
Well, just for
to drive that into
the table
conversation?
floor layout isn't subject to robberies, thefts. I mean that kind of thing. So you would want to look for the optimal, security.
Okay.
Well, it's those things. I really wouldn't want us to go down the path of trying to define each and every one of those terms that have to be very case specific, especially in light of the fact that we already have a plan that complies from the people who are commenting, that complies with everything that we thought we wanted.
Okay.
So where are we on this process? Is there a motion? We needed to move
If there
to-
is a motion, this is to take it through the final promulgation process, so we have an amended small business and
Mr. Chair, I move that the commission approve the amended small business impact statement from 205 CMR 138.07, 138.66, and 151.01 floor plans as included in the packet.
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
I also move that the commission approve the final version of the 205 CMR 138.07, 138.66, and 151.01 as included in the packet, and authorize the staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation promulgation process.
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
The next regulation on our list is 205 CMR 138.20. That's possession of firearms. You might remember from this regulation that we actually included the language in the reg that has to appear in the sign. And when we promulgated the reg, we put in Plain Ridge Park's phone number. So clearly that's not the right phone number for everyone. So what we've done is change this reg to leave the sign language with a blank so that the appropriate facility's phone number can be included.
Discussion? Questions? Motions?
Mr. Chair, I move that the commission approve the amended small business impact statement for 205 CMR 138.20, possession of firearms as included in the packet.
Second?
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
I move that the commission approve the final version of 205 CMR 138.20 as included in the packet and authorize the staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation formulation process.
Second.
Oh, this is .2, not .02, right? Okay. In discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
The The next regulation before you is a series of changes to a couple of regulations regarding unsecured funds and gaming day, and I'll leave that to Mr. Grossman. We brought this before you before. We've made some changes and there's been an update.
You'll recall that this was before you at the last meeting. There was a comment raised by MGM relative to our gaming day proposal. We've since reviewed this, and they've reviewed this, and are now content with the proposal as written. So we're not recommending any further changes to that, and that you adopt it as it's written with a 6 a.m. to 5:59 gaming day. So that's the first piece of this proposal. The second piece of the proposal deals with unsecured funds, which you'll recall is essentially cash or whatnot that's located in the slot machine during a drop or collection that didn't make it into the drop box, and how that particular currency or tickets are handled. We set that forth here. We also have provisions in here that deal with the event of any overage or underage during the count process and how that gets handled. So those are contained here too. We do have one proposed change based on a comment we received from Plainridge Park Casino, and you'll see that reflected at the bottom of page 1, where we have crossed out some language and then included some new language in green on page 3. Essentially what we are doing is saying that instead of counting an overage as unsecured funds that essentially we sweep into our control, they will become part of the investigation that gets performed by the casino, similar to that would be done in the case of an underage or lack of proper funds based upon the meter read. They investigate it and report back to us as to the source. So that's the one change that we're recommending to you that came through as part of the comment period. Otherwise, we would recommend that the commission approve these changes to be adopted.
Great. Do you have discussion? Do you have a motion? Was the issue of the gaming day that MGM raised, but this didn't correspond with their bookkeeping gaming day, right? That was the problem.
It was, but it was sorted out.
Yeah. Okay. So they ended up one way or another. They figured that out. Okay. Okay. Do we have a motion?
Sure, I'll be happy to move that the commission approve the amended small business impact statement for 205 CMR 138.28, 138.33, 138.68, and 140.02 on secure funds and gaming day as included in the packet.
Second.
Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
And I further move that the commission approve the final version of 205 CMR 138.28, 138.33, 138.68, and 140.02 as included in the packet, and authorize the staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation promulgation process.
Second. Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
And then the final regulation today before you is 205 CMR 141.06. This regulation, there's a few technical amendments to this, but the biggest change is that it requires a licensee to notify the commission prior to making any movement in terms of slot machines or table games. Our original regulation said that we would get notification upon the movement, and obviously we'd like to know beforehand. So we've taken this through the process, and this is the final step in promulgating these changes.
Why did we decide to do this? What difference does it make?
Well, every once in a while, the casino would relocate a camera. We wouldn't know about it.
Oh, looking.
Yeah.
Oh, CCTV equipment.
Yes, and actually the floor is set up with our approval on each one that we can adequately see each table. And if they just start to not notify us and move it around, we lose control of the floor in that sense.
Right. Okay.
I move that the commission approve the amended small business impact statement for 205 CMR 141.06, notice to the commission of changes as included in the packet.
Second.
This is really tiny, but you don't say the moving of CCTV equipment. You talk about replaced, including a change or an upgrade to system hardware. Are you talking, do you mean to be talking about changing camera locations? Because it's not covered here. That isn't covered here.
Well,
we're
including any change. CCTV, it includes any change.
And we're looking
What?
at two.
To system hardware. Change to system hardware. All right, it's really it's a detail, but if
But the hardware is the camera, for example.
okay. Okay, that covers move. You think it covers move? Okay, fine. Right. I told you it was tiny. Any further discussion? Any other useless points to make? All in favor?
Aye.
Aye.
All opposed? The ayes have it
Did
unanimously.
we have a motion on that?
We did,
Yeah,
in
I
a
did, yeah.
second.
Got
You
that?
need
I
a
think
second.
I moved.
Enrique
I
made the
second.
motion.
I second. No, Commissioner,
I moved, and I
Okay.
think
and I second.
Enrique seconded.
You need the second
You
one.
need the second one.
And finally,
All right.
thank you. I move that the commission approve
shut
the
up.
final version of the 205 CMR 141.06 as included in the packet and authorize the staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation promulgation process.
Second.
Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
That's all we have. Thank you.
Thank you very much.
Thank you.
Thank you.
Counselors, is there any other business that was either unanticipated, or do we have any commissioner updates?
Enrique.
I actually have an
Good.
update. I attended the New Horizons conference and Games and Summit in Vancouver this last week, and I thought that this was my first time going. I had heard from Director Van der Linden and others that this was a great conference to attend to in the area of responsible gaming, and I was not disappointed by any means. It's a great conference, and it was great to see the GameSense Summit and others that are implementing GameSense around Canada and the United States in ways that we are. I want to say something we've said before here, that we continue to be recognized as very progressive in this area by all the work that we've done. There was a delegation from Japan who was very interested in coming to visit Play My Way, to see Play My Way, and as well as the GameSense space here, and how that all might turn out to be with MGM. And it was very good to speak to them, and they were very impressed with some of our history, our recent history, which they draw a lot of parallels to as what they're going to. And I have to say that MGM was really showcased there with their own efforts on implementing GameSense. There's a real sense of an expectation of how that is all going to work with an operator, because up until then, it had only been bodies that in Canada, there's BCLC, of course, but they have a different sort of framework for the oversight and regulation of that. And they really have what I believe to be a great story to tell in how quickly and effectively they're deploying GameSense throughout all of their MGM, yeah, throughout all of their properties. So that's one area that I think I'd be very curious to go see at some point when they deploy GameSense to some of the properties in the Northeast or Vegas, because they are doing that and they're seeing quite a bit of great feedback from both employees and customers.
I was going to comment on that too, that and incredibly valuably, we're going to have research evaluation of the GameSense when it's administered by an operator, a regulator, sorry, like us.
Yep.
versus in MGM, for example, in Maryland, where they'll have it just integrated only with their own M-Life program. And we'll be able to do evaluations to see, you know, whether or not the effects and uptakes and so forth are more or less comparable, and which will be great. And but I agree with you that it was appropriate to single out MGM because they've gotten real credit on, they deserve credit on
Deservedly.
taking a really serious corporate lead on this.
Yep.
On responsible gaming generally, usually.
Commissioner Zuniga, at the conference, was there any discussion of the introduction and employment of play management tools like our Play My Way?
Absolutely. Actually, Mark van der Linden, Director van der Linden, presented in 2 panels. The one that I'm remembering most recently was specifically on Play My Way. He had, really essentially the history that we are all familiar with. Again, a lot of great questions relative to from the audience, relative to the fact that we are the first ones to do that in the United States. There's a lot of people from Canada and elsewhere in that conference, but they recognize that our context is slightly different. And a lot of expectation on the evaluation that we're doing. As we're all familiar with it, there's a good first report, but some of that evaluation continues, and there's a lot more that we're hoping to do. And again, a great set of days.
Great. Anybody else? Do I have a motion to adjourn?
So moved.
Second.
Second.
All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously. Thank you all.